No.
Okay, good afternoon, everyone. It's now 2:30 p.m. and we're officially live. Thank you all for joining us for today's presentation. My name is Jaleesa with Legal Aid of North Carolina's Helpline. Today we have Holly Owner presenting for us. If you are unfamiliar with the format of this event, Holly is going to review a PowerPoint presentation. At the end of the presentation, we'll have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or the comment section on Facebook. We'll review all questions put in the chat boxes during that Q&A session at the end. Please remember that this is a public forum and legal aid is not representing you at this time. Holly will go over this in more detail, but please remember to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions. Regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Holly to get us started.
Thank you, Jaleesa. My name is Holly Owner. I am the practice group manager for the housing practice for Legal Aid of North Carolina. And today we're going to talk about tenants' rights. Next slide. So this slide just covers our firm. We are a statewide nonprofit law firm, and we provide free legal services in a variety of different areas of practice, which include consumer, disaster relief, domestic violence, education, employment, expunctions. But as I said, I am the practice group manager for the housing practice, and that's what we're going to be talking about today. Next slide. These are the things that we'll go over. We'll spend the majority of our time talking about the eviction process, or in North Carolina, we call that summary ejectment. And we'll spend some time talking about repairs, rent abatement, habitability. That means if you have issues with conditions in your home, and then a little bit about security deposits. Next slide. So oftentimes before an eviction is filed against a tenant, the tenant will receive something called a notice to vacate. And oftentimes these notices are required in order for a landlord to even begin the process of evicting a tenant. Oftentimes they're required by the lease, or if you live in subsidized housing, then these notices are required by federal law. And there's also some state law that requires notices in certain circumstances. So a notice is just like a communication from your landlord asking the tenant to leave the residence. They can be given in writing, verbally, or electronically, but oftentimes the lease will describe, and oftentimes the lease will say it needs to be given in writing. And the notice is usually going to say that the landlord wants the tenant to be out, and then give a date by which the tenant needs to be out, or a number of days. A notice to vacate from your landlord does not mean that the formal eviction process has started. And oftentimes if a tenant leaves the home when they receive the notice to vacate, or in that time frame, they'll avoid the court process from being initiated. Next slide. So after a tenant has received a notice to vacate, then if the tenant continues to stay in the home, the landlord may file a court case against the tenant. If the landlord wants to remove the tenant from the home, they must do so through the court process. Next slide. If the landlord does not file an eviction action in court, if they do any other kind of thing like change the locks on the doors or try to get rid of the tenant's belongings, turn the utilities off, anything like that, We call that a self-help eviction, and those are illegal. But if they follow the legal process, then they will file a case against the tenant. Like I said before, we call this summary ejectment. That's just another word for eviction. The tenant receives a summons and a complaint. Those are the two main documents that you'll get. Oftentimes, the tenant will find that posted on the door by a sheriff, but the sheriff may also bring it and hand it to the tenant personally, or it also might come in the mail. The two main documents that the tenant will receive is the complaint and the summons. The complaint is what the landlord fills out as the reasons for why they're filing the eviction. And the summons gives the date and the place and the time that the hearing will happen. Like 99% of the time, these cases are first heard in small claims court in front of a magistrate instead of a judge. They're like a judge. Next slide. So there's only 4 legal grounds for why a landlord can file an eviction. A landlord cannot file an eviction during the lease period just because they don't like the tenant or because they want to. There has to be one of these 4 situations has to exist in order for a landlord to file an eviction. And these are indicated on that complaint by boxes. And so the first box on the complaint that might be checked is non-payment of rent. The second is holdover, which means that the tenant's lease period ended, but the tenant stayed past the lease ending. The next one is an allegation that the tenant breached the lease. So there might be a provision in the lease that says that the tenant can't have a dog. And if the landlord says that the tenant had a dog, that could be an example of breach of lease. Or the landlord could allege that the tenant engaged in some kind of criminal activity. But there's only certain kinds of criminal activity that are eligible. Next slide. This is the example of the complaint. This is what the form looks like, and those are the 4 boxes I mentioned that correlate to those 4 grounds for eviction. Next slide. Okay, the first one, non-payment of rent. If the tenant does not pay their rent on the date that it's due, and the landlord and the tenant do not have a written lease, then the law says that the landlord has to make a clear demand for the rent, wait 10 days, and then they can file an eviction against the tenant. This, like I said, is used if the landlord and tenant do not have a lease. If this box is checked, then the tenant has the right under the statute to pay everything that they owe. They have to include court costs in that payment to the landlord, or they can pay it to the court, and that should stop the proceedings. Next slide. The next ground, or the second box on the complaint, is for holdover. This means that the tenant stays past expiration of their lease. Oftentimes, when a tenant moves into a new home, they'll sign usually a year-long lease. At the end of that year, it's possible that the tenant will continue staying in the home and continue paying rent. That means that there is still a lease in effect, even if the tenant doesn't sign a new lease. But if the tenant continues to pay rent and the landlord continues to allow the tenant to stay there, then the tenant turns into a month-to-month tenant, and if they pay their rent monthly. But this is, so that doesn't mean the tenant is a holdover. The tenant only becomes a holdover if the lease ends and then the landlord communicates that they want the tenant to leave through that notice to vacate we talked about earlier. And if the lease doesn't say how much notice that the landlord has to give the tenant for notice to vacate, then the law says that the landlord needs to give the tenant 30 days if the tenant is in a year-long lease or has completed a year-long lease, 7 days if it's a month-to-month lease, and 2 days if it's a week-to-week lease. Next slide. The next ground or the third box is breach of lease. And you just want to make sure that you read your lease very carefully to know what all the rules about your tenancy are. If you break one of those rules, then the landlord can file this action against you, and they have to describe on the complaint what you've done to breach the lease. But also not paying your rent can be considered a breach of lease. And so the landlord might elect to evict a tenant based on breach of lease for not paying rather than the first box, non-payment. Okay, next slide. And the last box is criminal activity. So I mentioned that it's certain types of criminal activity, and that is defined by state law. The criminal activity has to either be a violation of the North Carolina Controlled Substances Act or other criminal activity that threatens health, safety, or right of peaceful enjoyment. In these cases, there are certain additional procedural things that a tenant needs to do. A tenant can be held responsible for actions or of other household members or guests, but there are some ways that if a tenant wants to stay in the home, there's a way for a judge to evict just the sort of offending person from the lease. Or if the person is not on the lease, conditional eviction means that the tenant can stay in the home, but is agreeing to let that person be banned. And if that person comes back, then the tenant automatically gets evicted. And the criminal activity will also be described in the complaint. Next slide. So even if a eviction action is filed against a tenant, there are ways for the tenant to defend themselves. Always call legal aid because, again, we provide free legal services in these kinds of cases, so long as you're eligible for our services. But some of the defenses are if the tenant is a victim of domestic violence and the eviction is based on them having been the victim of domestic violence. Waiver means that the landlord knew about the breach that the tenant committed, but allowed the tenant to stay and continued collecting their rent anyway. Invalid notice is a very common one because, like I said before, the landlord is required to give specific type of notice, and the notice has to say certain things. And if the notice doesn't do that, then the eviction case can be dismissed. There are a lot of protections under the Fair Housing Act. And so if you're a person with a disability and you ask your landlord to sort of make a reasonable accommodation based on your disability, and the landlord doesn't do that or doesn't follow the procedures they need to follow under the Fair Housing Act, that can be a defense. Yeah, some other defenses. So again, the best thing you can do in that situation is to contact legal aid. Next slide. Did you skip one? Yeah, okay. So after you receive a complaint and summons, like I said, you'll probably get that on your doorstep, or if the sheriff delivers it to you, then you will have the tenant will have a hearing scheduled. If the tenant does not appear at the hearing and the landlord does appear, then typically the judge will automatically enter the eviction judgment. If the tenant does appear, then the tenant has the opportunity to present a case. The landlord presents their case first. The tenant has the opportunity to cross-examine the landlord or any other of their witnesses. And then the tenant has the opportunity to testify, tell the magistrate or the judge anything they want them to know, and provide or present evidence. In order to present evidence, it's really important to print things out in advance. A lot of courthouses don't allow the public to bring in a phone. So if there are text messages or pictures that you have on your phone, you want to make sure you print those out. And it's helpful to have 3 copies so that you can give one to the other side, the landlord or the landlord's lawyer, one to the court, and you can keep one. Magistrates appreciate when tenants show up prepared, on time, and having copies of their evidence. Tenants can also bring other witnesses to testify. So after the tenant, then the tenant can call witnesses just like any lawyer can. If the landlord tries to testify about things that they don't know about, the tenant can object to that. And magistrates then will often make their ruling right away on the spot, and either they will say the case is dismissed, which means the tenant gets to stay in their home, or they'll say a judgment for possession is being entered, which means that they're allowing the eviction. They're granting the eviction for the landlord, but sometimes they don't make that very clear. So it's important to know the phrase judgment for possession, which means that the tenant is being put out of their home. Next slide. So if the tenant, if a judgment for possession is entered in small claims court and the tenant, so that means the eviction has sort of been granted, the tenant has 10 days to file an appeal of that decision. And filing the appeal can allow the tenant to stay in the home for a longer. In order to file an appeal, the tenant needs to fill out a notice of appeal and fill out a petition to proceed as an indigent, and also fill out another form that describes the rent bond. You can get all of those materials on our website, or you can get them just at the North Carolina Courts website, or you can get them oftentimes from the clerk's office. But there are 3 main forms that you want to get: the notice of appeal, the rent bond form, which is called the bond to stay execution, and the petition to proceed as an indigent. You want to fill all 3 of those forms out. Mostly the forms are just writing the parties' names and the date that the court case happened, your rate of rent, some just pretty basic stuff. The tenant also typically will have to pay an amount of rent in order to perfect the appeal and stay in the home while the case is pending. The amount of money that the tenant will have to pay is based on what their rent is, and the tenant has to pay that money as if it's their rent that they're paying to the landlord, but they pay it to the court, to the clerk's office, and the tenant pays it as it comes due, just like they would to their landlord. If the tenant is able to file the appeal and perfect the appeal by paying the rent bond, then eventually the trial will be set in district court in front of a district court judge, and a new trial will happen totally fresh. So nothing that happened in the hearing in magistrate's court will affect what happens in the new trial in district court. If the tenant does not file the appeal or pay the rent bond to perfect the appeal, then on the 11th day after the hearing, the landlord can go to the clerk's office and ask that the clerk issue a writ of possession, which we also sometimes call padlocking papers. And then the sheriff will go out and execute that writ of possession and remove the tenant from the home, typically about like 5 to 7 days later. Next slide. So this is, again, the padlocking process. If the tenant does not file the appeal, or if the tenant files the appeal, has their case in district court, and then loses there, then the landlord needs to then take this next step of getting the padlocking papers, and then the sheriff is the person who ultimately removes the tenant from the home. After the sheriff does the padlocking, the tenant does have 7 days to get their belongings. But the tenant needs to communicate with the landlord to be able to schedule when they can go to get their belongings. It's very important that a tenant does not go back to the home after being padlocked because it is considered a crime. Next slide. Okay, this is just kind of a summary of the process as I just described it. Next slide. Okay, so that's everything about the eviction process. This is about a landlord's duty to provide a habitable home. Next slide. So a landlord has to follow the local housing code, which some cities and towns in North Carolina have specific local housing codes. If they don't, there's a whole state law about duties that a landlord has. The landlord must repair dangerous conditions in a reasonable time, keep common areas safe, keep electrical, plumbing, sanitary, heating, air conditioning, other facilities and appliances in good and safe working order, install smoking carbon monoxide detectors. There are other things as well that are listed in the state law and that local housing codes. These duties cannot be waived or avoided by the landlord. It doesn't matter if the landlord tries to put in your lease that the tenant is renting it as is, or that the tenant is waiving their right to a habitable home. None of that is enforceable. The law says that the landlord must do these things and they can't get out of doing it. The law also says that the tenant has to continue to pay rent while they are making requests for repairs. And that there's not an automatic right to withhold rent. Next slide. So if the landlord does not do their duty, so essentially if a tenant is living in a home and an issue arises, like there's a foundational issue or a leak, an issue with plumbing, your heat goes out in the winter, the AC goes out in the summer, issues of rodents or anything like that, then the first thing the tenant needs to do is document what the issue is. So take pictures, take a video, document whatever is going on. The second thing is that the tenant needs to communicate to the landlord what's happening and ask for the landlord to make repairs. It's really good to do that in writing. So in a text message or in an email, so that you have documentation that you have told the landlord, put the landlord on notice of the issue and ask them to fix it. But if they don't do it still, if they don't make repairs after that, then a tenant may be eligible to have some of their rent given back to them. And that's what we call rent abatement. And next slide. So if the landlord has filed an eviction against the tenant, or if the tenant wants to file their own lawsuit against the landlord because of conditions, the tenant can argue to the court that there are conditions in their home as a defense to not paying rent, or just file their own case against the landlord. But either way, you want to be able to bring evidence if you're trying to show the court that you are a tenant who is experiencing habitability issues. So if the landlord files a case for non-payment against a tenant and says that the tenant hasn't paid their rent in a month, but the tenant says, well, it's true that I haven't paid my rent in a month, but for 6 months, I've been living in these really bad conditions. And so I shouldn't really owe any rent, because for 5 months I paid my full rent when I really shouldn't have been paying the full rent. I should have gotten a credit back. That's a time when you can bring this up as a defense in an eviction case. But either way, you want to be able to bring evidence to show your issues with your home. And that evidence is going to be, again, pictures of the conditions or videos, which you want to try to print out if you can. If it's a video, you can try to put it on a hard drive, or you can specifically request permission from the court to bring your phone inside. Also, you want to call your local code enforcement office if your city has a code enforcement division. They will come out for free and do an inspection. And then those inspection reports should become public documents and are sent to the parties so that you can show that to the judge. And then also, as a person who's living in these kinds of conditions, you can testify about what kinds of issues are going on, or you can have witnesses come and testify. Next slide. So I mentioned that if you haven't paid rent, if a tenant hasn't paid rent, but they're explaining to the judge that they really didn't owe rent because they should have had a credit because they've been living in bad conditions, the way that works is that if your rent is $1,000 under your lease, but the conditions are so bad that you're meant to pay $1,000 for the thing that you signed a contract for, which is a habitable home. If you don't have a habitable home, then it's not worth the amount that you signed the contract for. So then as the tenant, you have to determine what your house is worth based on what it is with those conditions. And so a house that doesn't have heat in the winter is not worth the same as a house that does. And so then you get the difference in that. Next slide. Okay, that's everything about conditions. And this last bit is just about your security deposit. Next slide. A security deposit is typically an amount of money that a tenant pays to the landlord upon moving in or upon signing the lease that is reserved for any kinds of damages that are done to the property for the landlord to make repairs for damages done to the property by the tenant after the tenant moves out. There's a state law that describes exactly how a landlord can use the security deposit. They cannot use that money for just anything. 30 days after the tenant moves out, the landlord must return the money or provide the tenant with a list of what they're using the money for. Normal wear and tear cannot be deducted. A landlord can ask for additional time to provide the itemized list. So within those 30 days, the landlord can request in writing more time than they get 60 days. But a good practice tip is that when a tenant is moving out, they should take pictures of the home as it looks at when they move out. If the landlord refuses to return the security deposit or does not provide an itemized list in the proper amount of time, the tenant can sue the landlord in small claims court to have the money returned. Next slide. Okay. That's it. Are there any questions?
Looks like we have one question. One moment. So the question here is, it says, what are all the agencies to report a complaint of unsafe conditions at an apartment complex after already reporting to the landlord without proper response? And then the second part to this question is, what is the order of filing reports for proper investigation to government agencies?
So if I'm understanding the question correctly, if you're trying to report like a habitability related issue, like an issue with the conditions of the home, doesn't matter if it's an apartment complex or not, then the proper place to contact would be the local housing code enforcement division, which is typically run by the city or the town. And so you would just probably want to Google the name of your town or city and code enforcement. Not all cities and towns have them, but many do. If you wanted to report something like related to fair housing, then that would be like the your local fair housing commission. And again, if you just Googled like the place that you lived and fair housing, then it should come up with the local agency that hears those kinds of complaints. And I would encourage anybody who is experiencing severe habitability issues and you've documented and you've made requests for repairs to your landlord, if none of that is working, to contact legal aid.
Okay, the next question we have is, can I be sent a copy of this information in the slides?
So just wanted to let everyone know, we'll review this, is that this presentation will be immediately available, so you'll be able to review the slides at any time on our Facebook page. Jaleesa will explain that a little bit more later, but this information will be readily available following the presentation.
Okay, we're not seeing any more questions online. I just want to remind everyone that you cannot unmute in this forum, but if you have a question, you need to type it in the Q&A section on Zoom or the comment section on Facebook. We'll take a few moments to see if any additional questions come in. Okay, look, one moment.
No, just go ahead.
Okay, so it looks like we just received one question here. Says, I have an upstairs neighbor who smokes. There's nothing in my lease that says that this is a no smoking property. Although when I moved in, I did see that the apartment was advertised as non-smoking. I cannot use my patio because of heavy smoke fumes. What recourse do I have?
So I can't give direct advice about a particular situation in this forum. And I would just say that legal aid, we represent tenants who are either facing eviction or experiencing like some kind of habitability issue or something like that. So that wouldn't really be something that would be within the purview of what legal aid would do. Sorry.
Okay, no worries.
Okay, it looks like the next question is, if a tenant raises a health and safety concern to the landlord, and then a week later, the landlord sends a notice, non-renewal of lease, is that clear retaliation? The year lease is ending over 60 days away.
Again, I can't give specific advice related to like specific situations. Retaliatory eviction essentially is a part of the law that says that if a a tenant should be free to be able to exercise their rights without fear of the landlord retaliating by evicting them. There was a case that came out in the Court of Appeals of North Carolina about a year or two ago that made it a lot harder for tenants to be able to successfully bring a retaliatory eviction defense. That doesn't mean that it's impossible, but it's a lot harder. I would just say that that would be a type of case that you'd want to call legal aid about.
Okay, so it looks like there's no more questions online. Again, I want to thank you all for joining us, and a special thanks to Holly for presenting. If you would like to review anything that we talked about today, we have posted the recording of today's event to our Facebook. It will be immediately available. You can access this with or without a Facebook account at www.facebook.com/legalaidnc. If you would like to register for one of our other Listen and Learn presentations, such as expunction, Medicaid, and Social Security, you can do so on our website, legalaidnc.org/clinics. Have a great day.
Thank you.